Chief Technology Officer, or OCTO, is the central technology organization of the District of Columbia government. OCTO develops, implements, and maintains the district's technology infrastructure, develops and implements major enterprise applications, establishes and oversees technology policies and standards for the district, provides technology services and support for district agencies, and develops technology solutions to improve services to businesses, residents, and visitors in all areas of district government. OCTO's mission is to direct the strategy, deployment, and management of DC government technology with an unwavering commitment to IT excellence, efficiency, and value for government, residents, businesses, and visitors. The mission of the Office of Risk Management is to reduce risk to the DC government through risk identification, insurance analysis, and support to the district's agencies. ORM is responsible for the facilitation of the Workers' Compensation Program, Risk Prevention and Safety Program, Risk Insurance, and Tort Liability. This morning, I'm looking forward to discussing the How Am I Driving program, which is the bumper sticker-based program that helps ORM track driver performance and keep the road safe. ORM has made improvements to the process, but some agencies are still not responding to cases. We'll also discover the public sector workers' compensation program because I've continued to hear alarming things about district employees' lack of rights in the process. I look forward to hearing from our public witnesses about the important work of both these agencies. Some logistical announcements for today's hearing. In addition to Zoom, this hearing is being live broadcast at briannecanedo.com/live. To ensure that we hear from all members of the public, I ask that witnesses stick to their allotted time. Witnesses testifying on behalf of an organization will have 5 minutes to provide oral testimony, and all other witnesses will have 3 minutes. For those participating in the hearing via Zoom, when it is your turn to join the panel, you will receive an invitation that you will need to accept to be promoted. And then at that time, you'll be able to access your microphone and your camera. I will call your name when you are about to be promoted. For any technical difficulties, you can send a message to the host labeled as Committee on Public Works and Operations or any panelist labeled committee staff, and we'll follow up with you. If you're having trouble accessing the Zoom, please email publicworks@dccouncil.gov, and we will try to resolve your issue that way. Okay. Okay. Just one quick announcement. Originally, this hearing was scheduled to have not only public witnesses, but also government witnesses for both agencies. Due to unforeseen circumstances, the Chief Technology Officer will not join us today. We will reschedule him at a later date so that we can ask him questions about the testimony that we heard today and also follow-ups to the written responses that the agency sent us. But for now, we have one panel of public witnesses. And all right, we're going to do them all at once. So Ms. Shauna Dillevo, CEO of Bright Lines, Fritz Mulhauser, DC Open Government Coalition, Will Crane, VP FBA, Benjamin Douglas, Commissioner Chuck Elkins, Scott Price, and Mr. David Maloff. We're going to start here in the room with our in-person witnesses in the order that I called you. And when you're ready, you may begin.
Ready? All right. Good morning. My name is Shauna Dillevo. I'm the founder and CEO of Bright Lines. We are a doxing prevention company. If you don't know what that means, you're not alone, but we're learning fast, aren't we? We find our clients' risky data online and we remove it. We are a DC headquartered company, and many of our staff and clients call DC home, myself included. You're my neighbor. I started this company in 2021 with the hope of supporting our democracy. We aim specifically at protecting people running for office, as well as those working to keep elections free and fair. And I never thought we'd be as in demand across so many sectors and groups of regular folks as we are today. I spend a lot of my written testimony explaining the problem of doxing, and I need it to be very clear. We do doxing prevention across all 50 states, and nowhere are residents more vulnerable, and nowhere are they as targeted as DC. council member and members of this committee don't need me to tell you what it's like to be a public figure, to understand and take on the risks you and your families do for your selfless service and leadership. However, it's the folks who get targeted for just being a civil servant or a victim advocate or a medical professional that I'm concerned about. These are average folks who never suspected that their work would land them in the hot seat or threaten their families. And these past few weeks have made it incredibly clear that they are not safe in DC. I referred to the mostly Black healthcare workers profiled in the DEI watch list, or the scores of folks at DOJ who are being targeted because of their involvement in the January 6 cases. These folks didn't opt into a life of scrutiny, and they've had no choice in the matter. The difference is, if you're an elected, and for a lot of our federal judges and federal folks in DC, they have the Marshal Service. You have the police. They will believe you. They will support you if you call them. But what about the rest of us? The OCTO data sets, let me say it plainly, create risk for DC's residents without hyperbole. They will get someone killed. I do not expect that an attacker would know to go to the open data website and pull down the integrated tax data set. That would be silly, right? To assume that they would create an account on Scout and go look up a target by name. But you know who does know about these websites are data brokers. And there are thousands of them. And there are literally more every week. They are hungry for data. And the really good stuff and the really cheap stuff comes from these public records. Data brokers are a $320 billion industry for the folks following along at home. That's almost as much money as Elon Musk's net worth. And because Mr. Musk shut down the CFPB, the only agency that was attempting to curtail data brokers, were left with no protections. DC residents didn't get a choice when the DMV sold our data to LexisNexis. We never got an opportunity to opt into these data sets being out there shared like they are. And like I said, I do believe it will quite literally kill some of us. I urge the committee to direct OCTO to remove all data sets from its public-facing enterprise lists that connect constituent names and addresses. And to know that they would need to audit those data sets to understand what's out there and what's sensitive. And, not for nothing, OCTO may need to update their data classification guidelines, particularly where PII is involved, now and at a regular cadence. That needs to flow down to the agencies, obviously. And I would argue that the city may need to consider reorienting from a transparency first mindset to a constituent consent first mindset when it comes to our data. We understand that there are some statutes that conflict with the consent-based data sharing, and that needs to be ironed out. And to that end, we would love to see coordination, maybe in a coordination position between the CDO and the CISO within the office of OCTO, or maybe an office itself needs to be created. And we get it. The drafters of the open data policy could not have anticipated the security concerns we face in 2025. But the physical implications of these data sets present a clear and present danger to our residents. And we would love to be of service and to help.
Thank you very much. Mr. Mulhauser.
Good morning, Madam Chair. I'm Fritz Mulhauser. I'm co-chair of the legal committee of the DC Open Government Coalition. We're a community group active for going on 16 years to advocate for the effective implementation of important laws which give everyone in the district the right to know what their government's up to. Those include the right to public records through the Freedom of Information Act, the right to attend public bodies' meetings through the Open Meetings Act, and the right to access to data through the mayor's data order. We're here today to talk about OCTO because they have a role to play in regards to the Freedom of Information Act. It's not something they chose, and it brings them into daily contact with the public, which is also not a role that the highly skilled technical experts there would choose to play. In the district government, services are delivered by mission agencies. But in the case of the Freedom of Information Act, OCTO is right in the middle of delivering a key service. And we think there's great room for improvement. Let me explain. The first thing that OCTO does in this regard is to take in requests under the Freedom of Information Act. Beginning in 2014, they had a contractor who repurposed federal government-oriented software for handling FOIA requests. We had lots of problems with that system. It wasn't user-friendly. We made many forays to talk with OCTO, mostly unsuccessful. We filed complaints with the Open Government Office. They issued an agenda of improvement, which OCTO never responded to as far as we know. They changed the contractor last year. We testified to you to slow it down so users could be heard. Didn't happen. They bought a new system. We'd heard of problems throughout the country. We were never able to get those listened to. There were problems at the rollout, but it's gotten a bit better, but there we are. That system takes in thousands of requests every year and also allows agency staff to post the progress of processing. The second key thing which OCTO does was mandated under the mayor's data order in 2017, which, as my colleague just commented on, requires the publication of data sets held by agencies. So thousands of data sets throughout DC government on children, on health matters, on police matters. They had to be reviewed, and those that pose no risk should be published. And the mayor's data order said that Freedom of Information Act requests in the database compiled by the acceptance portal should be published. And OCTO has not done that satisfactorily. The problem is that only completed requests are published. And that means that the public cannot keep track of incomplete ones. We tried to do this starting in the pandemic when backlogs were huge. And it's still the case that only completed requests are available. We've asked repeatedly for extracts from the database. They've been denied. We filed a request for the entire database, and it was denied. So we're here to ask you today, number one, please ask OCTO to publish in full their current set of requests, completed and incompleted, as compiled through the GovQA portal that takes in public requests. That way everybody can keep track of how we're doing. In the long term, we ask you to join with other committees to take a broader look at the implementation of the Freedom of Information Act. The law itself needs revision. It was written 50 years ago in Congress, and DC copied it. We spoke earlier with Chairman Pinto in the Committee on the Judiciary, who asked probing questions about the performance of the FOIA system, which can't be answered by the Office of Open Government under that committee this year. They don't manage the system. They don't keep the data. OCTO does. But OCTO, as I said before, is not a public-facing agency. It doesn't respond to the public very well. The operation of the FOIA system should be brought together in one place. The statute should be revised. The statute should be revised so that the Office of Open Government can decide appeals with binding effect, we hope, gather the data, manage the data, talk with agencies about performance improvements. 3 or 4 agencies manage 40% of the FOIA requests. If we just worked with them, we'd do a much better job. So a broad program of reform needs to be initiated, and we look forward to working with you. We've attached a proposed commission bill to our testimony today, which would give the council a good start after 6 months of work by experts to advise on how that law, all the laws should be rewritten. Thank you so much.
Thank you, Mr. Mulhauser. Mr. Crane?
Morning. My name is Will Crane, and I'm the Vice President of the Foggy Bottom Association. I'm not going to use 5 minutes because I'm just speaking as an individual here. Okay, is that better? Okay. I wanted to thank you for providing this venue to talk about ORM performance and allowing to discuss my experience as a simple citizen who has been dealing with them for the last 12 months. I'm a resident of SMD 2A03, and as a realtor, my car is an essential tool to conduct everyday business. And I want to thank the council first for promoting electric vehicles. In December 2023, an historic district sign located in the residential alley of Snow's Court fell off of a pole and damaged my car. As the chair of the Foggy Bottom Association Infrastructure Committee, I was aware of past association attempts to have these old signs repaired and replaced. So trying to avoid an insurance claim and the inevitable perpetual increase in insurance premiums in an already very expensive insurance market, I made a claim with ORM on March 6, 2024. They acknowledged that on March 7th, 2024. As I speak today, the only official written response from ORM was received on January 9th, 2025. This was a denial letter that did not pertain to my incident, and my emails notifying ORM of the error have gone unanswered since that time. I'm grateful this is not a case in which someone was injured, but the lack of timely response, and since ORM is a public-facing agency in which people who have suffered loss have to deal with, I'm disturbed at the lack of response, especially in writing when we're having to deal with communications that are then sent over to an insurance provider. Thank you.
Thank you. We'll follow up after this. Mr. Douglas.
Thank you. So first of all, thanks to the committee. Thanks to Council Chair Nadeau. My name is Benjamin Douglas. I am an attorney focused on workers' compensation. I've practiced in the district for 12 years. Before that, I practiced in California, acquainted with a number of systems, and I am also a Ward 1 resident and I work in Ward 2. I'm here to express my dissatisfaction with the performance of the Office of Risk Management. As Council Chair, you are well aware, I think that the law needs to be changed. Many people believe it needs to be changed. And I appreciate your efforts, along with Councilmember Bonds and Councilmember George, to introduce the Public Sector Injured Workers Equality Amendment Act of 2023. And I humbly ask that it be reintroduced. The district private sector workers' compensation system delivers some of the best benefits at the lowest costs of any workers' compensation system in the country. And I could certainly complain for hours because this is what I deal with all day about that system. But the complaints are rather minimal compared to the complaints with the public sector system. As you noted, Council Chair, we're talking about a lack of rights and a lack of due process. The imbalances are just extraordinary. And it says on ORM's website that they are functionally the district's insurer, which is completely fine. I hear your concerns. They have to do their job as an insurance company still, or an insurance company-like entity. But the problem with the public sector system is that it lets them be adjudicator and regulator alongside their duties as an insurer, and that's an obvious conflict of interest that gives injured workers a raw deal. I noted all this in my written testimony, and I wanted to add to it that even looking at what their limited role is, I think they do a very bad job of it. There are inefficiencies, wasted costs. A case that would take about 2 hours before an administrative law judge in the private sector system often takes 7 or 8 hours in the public sector system. The administrative law system is supposed to have somewhat relaxed discovery rules, procedural rules, because we're not doing mass level civil litigation. It's an administrative remedy with imperfect remedies, no fault. And somehow in the public sector system, they make it consume large amounts of resources. It takes a lot of time from the Attorney General's office, and I think that's especially important now. I admire a lot of what the AG's office is doing. They got a settlement against Amazon for stealing tips from workers, and they're involved in the sadly going to be very ongoing litigation related to the lawlessness of the current presidential administration, and I want them to have maximal resources to do that. There are junior AGs that are spending hours and hours and hours paying orthopedic surgeons to testify for long periods of time for cases where it's really not necessary. it's an inefficient system on top of all the other injustices. And again, I could talk for hours, but I plan to talk for 3 minutes. So thank you.
Thank you very much. Commissioner Elkins?
Good morning. Recently, I testified at an oversight hearing at the Department of Transportation performance, along with my colleague Scott Price and other members of the Sidewalk Safety Task Group about a very serious problem that our sidewalks, their tripping hazards, are not getting repaired rapidly. The fact is that people are falling and hurting themselves on our sidewalks, and in many cases, we believe it's because DDOT is choosing to delay the repair of tripping hazards even when they have been told their location by residents. Falling is no joke. Nationwide, falls are the leading cause of injury-related death among people 65 years and older. In a survey of just 473 Capitol Hill households a couple of years ago, 305 households reported sidewalk falls within a 2-year period, with many experiencing multiple incidents. 114 of these falls required medical attention. Our in-depth examination of the way in which DDOT approaches the repair of tripping hazards has led us to conclude that DDOT is responsible for some of the falls that are taking place because they defer repair of some of these tripping hazards that are reported to them because they find it cheaper to just repair the problem when they do long-term maintenance on the portion of the sidewalk. And sometimes that takes many months longer. And yet, if one would look at the ORM awards for sidewalk falls, one would conclude that very few falls are taking place. And we know that's not the case. So what can account for this large discrepancy? Well, here's our guess. We understand that ORM has a policy that is interpreted as saying that a sidewalk hazard must be reported via 311 to DDOT in order for there to be any compensation. We understand the importance of this, that the district needs actual constructive knowledge that a hazard exists. However, we wonder whether ORM is giving proper credence to DDOT's other sources of actual knowledge of these hazards besides 311. We want to bring these additional sources of both actual and constructive knowledge to the attention of both ORM and this committee, with the anticipation that ORM can consider this information that DDOT has when ORM makes its determinations. Specifically in 2023, DDOT did a comprehensive study, a survey rather, of all the district sidewalks and classified them as to their physical condition. Hundreds of sidewalk segments were rated as either fair, poor, or very poor. DDOT has taken that knowledge in-house and is now scheduling repairs for the sidewalks identified as needing repair in that survey, as indicated in their pre-hearing submission to the Council's Committee on Transportation and the Environment. And I give a quote in my written statement there. This clearly shows that DDOT has actual or constructive knowledge of these tripping hazards and that there is no need to have them reported on 311 before ORM can find that DDOT has the required knowledge. Google Earth also has images of the district sidewalks dating back to 2007 that are accessible to DDOT and ORM, and we believe ORM should investigate these Google Earth photos when it's making a determination of constructive knowledge on the part of DDOT as well. Given these additional sources of actual and constructive knowledge on the part of DDOT, we would like to suggest that this committee request ORM to prepare a report for the oversight budget hearings next year, that is for fiscal year 2027, that summarizes the office's processing of claims related to sidewalk falls that would include the following information: the number of applications related to sidewalk falls, the number of applications approved, the actual or constructive knowledge on the part of DDOT that justified the approval, and the number of applications disapproved and the reason why. This information will help this committee, ORM management, DDOT, and the public evaluate how sidewalk falls are being treated and should give DDOT better information than it has now about the prevalence of sidewalk falls. Before I finish, I want to say that I see that David Maloff is testifying, and I'm a strong supporter of his request for your taking a hard look at DOB. This is because for the past year, I've been working with 4 other district homeowners regarding the hundreds of thousands of dollars in damages that they have incurred because of serious flaws in DOB's construction permitting system. In a report that we just completed, we lay out the problem and we provide 36 specific recommendations for reform in order to reduce the risk to homeowners. I hope this committee and ORM will be interested in what we found in identifying these serious risks. A copy of our report is attached to my testimony. Thank you, Madam Chair.
Thank you very much. Mr. Price?
Madam Chair, thank you very much for allowing me to testify this morning. My name is Scott Price. I've lived on Capitol Hill since 1976 and served as an ANC commissioner for 9 years. As Commissioner Elkins suggested, I've been working with him to try to improve DDOT's sidewalk maintenance policy. Commissioner Elkins referred to a report that we recently submitted to the Transportation Committee of the DC Council, and I uploaded that into the website for this meeting. I also uploaded information about the 2023 DDOT sidewalk assessment to your website. That assessment was completed by DDOT. They've had since 2023 to remedy problems. They've tried to remedy some of the problems, but still some of the problems exist. The important thing is that ORM should consider DDOT to be the expert on whether or not a sidewalk has a problem. DDOT classified the vast majority of sidewalks in DC as either good or excellent. It's only a small number, or actually it's a significant percentage, I think 7 or 8%, that DDOT itself classified as fair, poor, or very poor. And we recommend that should conclude ORM's assessment of whether or not actual or constructive notice of a problem has been received by the government. We are, I'm sorry. The issue is, what kind of city do you want to live in? Do we want to live in an, it's okay for DDOT and maybe even the city council to be cost efficient in identifying how much money they're going to put into sidewalk repair. The problem is if the sidewalk is known to be dangerous, the next poor unlucky guy or woman who walks on that sidewalk could be injured. And now under ORM's current policies, that person might not get their expenses reimbursed because DDOT, because ORM didn't have prior knowledge. But we think that 2023 assessment gives the DC government that prior knowledge. And of course, we want to avoid a problem where two agencies of the same government disagree. For DDOT to classify a sidewalk segment as dangerous, but then for ORM to say, well, it's not so bad. Thank you very much for the opportunity to testify today, and I'll be glad to answer your questions.
Thank you very much for your testimony. Mr. Malouf?
Thank you, Councilmember Nadeau. Good morning, and good morning, Commissioner Elkins. I am David Malouf, past president of the DC Federation of Citizens Associations. I have two respectful requests today for the committee. I'm here today to ask you to support my call for an arm's length internal review of the Department of Buildings residential permitting and inspections for DC Code Classification 3307 projects deemed dangerous. An astounding 7,000 permits were issued last year. A member of ORM staff should be seconded to such a quick 30-day government team to review report to the Deputy Mayor for Planning and Economic Development in whose cluster DOB resides. For the Director of ORM, I ask that as part of your mayoral oversight that your office contribute a staff member and co-lead an inexpensive internal review along with staff from DOB, MOLC, DEMPED, and perhaps even the DC Auditor. At the upcoming annual Committee of the Whole Oversight hearing for DOB on February 25th, the Council will hear yet again, chapter and verse, for over 3 years and counting, the need for a review and reform of DOB's positively broken residential dangerous construction permitting and inspections. As one most recent horrible example, the V Street Northwest property collapse that resulted in a worker's death around Christmas last year continues to reflect an official DOB permitting and inspections record full of deficiencies and omissions. This is especially heartbreaking after all the testimonies and work of many residents over the last 2 years who've offered input. This is important that the mayor, deputy mayor not rely solely on DOB's internal, potentially conflicted perspectives for the review of that incident or for the separate review of permitting inspections and inspections overall, which I once again call for at the council this year. Given the increased attention of DEMPED to economic development and DOB's apparent acceleration of permit issuance, I ask DOB nevertheless to be held to quality permitting and special inspections that do not leave residents physically endangered or stuck in lawsuits at Superior Court. DOB's first legislative charter is to protect the public safety and then also to advance economic development. The agency's annual internal budgets do not reflect or account for the continuing significant negative externalities that the agency continues to generate and unload on the unwitting public. ORM holds the power of legitimate oversight review to help extinguish the continuing dangerous transfer of risk and shifting of damaging costs onto abutting residents, onto workers, and onto the local neighborhoods. Thank you.
Thank you all for your testimony. Ms. Delaval. Do you believe that the Office of the Chief Technology Officer has the necessary policies and oversight in place to protect residents' personal information?
Yeah, I'll be honest, this is new for me to do advocacy. We're a
Yeah.
small company, we're only a few years old, and I don't know the code well enough to say. From the read of the code, from their responsibilities, from the structure of the organization, I'll tell you my take on it as a cybersecurity function. Like they seem to so a CTO's office, as you know, is like set up to be thinking about systems, processes, keeping data safe that way. What we find all the time is that without a CSO, there's a CISO, right? But not a chief security officer, not someone like in a corporate position like that. We don't see that often in cities because they're not yet thinking about how online data travels to folks in the real world. So this is kind of an emergent place. I don't know that the office has even considered it because I don't know that most have, I don't think the policy covers it. From what I've read of the CISO's position and responsibilities and the chief data officer, there is some understanding of that they need to coordinate around PII, personally identifiable information, PHI, sensitive data. And the classifications from 0 to 4, right, of like what is more confidential, what can be shared and not within the policy, it's not clear to me that the definitions take into account that PII has expanded beyond social security numbers. I say that thinking about the Department of Buildings, which I'll also be testifying at that committee, they publish, and the tax system, right? Like they publish your name and address together, but they'll remove transaction information about the sale of the property, right? Or if it's a recorder's office, right? Like they'll remove transaction information, they'll remove financial data, things that show up on an IRS document or on a tax form, but they don't seem to understand that PI, it should be inclusive of home address. It doesn't really answer your question. It doesn't seem to me that there's an explicit function.
Okay. That's helpful. You mentioned inconsistencies in how different agencies classify and protect personal information. What steps should the council take to ensure agencies apply data classification policies correctly?
Yeah, I think there needs to be an audit of the data, like I said, right? There are a couple of instances where the agency classifies it as a level 3 confidential, not even to be shared across agencies, and then it gets sold to a data broker, or the public extract of it includes sensitive information. So it's not clear that they understand what should be sensitive or not. I'm not sure if I understand the code correctly, that there is specific officers that manage records keeping within the agencies. It feels like there's just not an updated definition and it's not shared across agencies. And then when it gets applied, for goodness sakes, the Board of Elections specifically states in one of their level 3 data sets that home addresses are PII, literally says data such as home addresses, right? This is why this is a level 3. And then in their level 1 that they share, that they've shared with the people running voteref.com, they have home addresses in it. And now that website has our home addresses in it and publishes it. So it seems like they may also be struggling with the codes that they have to be compliant with. But it's clear that in that enterprise data set, there are hundreds of data sets, right? Like in that inventory. And that there isn't consistency even from the own, like a singular agency.
Were you referring to a particular agency when you said there are instances where data is a level 3 classification, but the data gets sold?
At the DMV. Yeah, that was a FOIA record that showed the contract had been signed.
Who did they sell it to?
LexisNexis.
Oh, you said that.
Yeah, so when our client went to apply for the ACP and was denied, it was because the ACP, the Address Confidentiality Program, found her information on LexisNexis. And so then we appealed to LexisNexis to remove the information, and they don't have to. They said, we may publicly suppress it, but we won't remove it. Meaning that if someone searched the database, they may not find it, but they would never get rid of it. And that doesn't mean that they won't sell it to someone else. So there's no remedy. And we've had clients who've made that appeal and LexisNexis turns them down because they don't have to remove anything.
Okay.
Yikes. Yeah. My concern is because we only looked at 4 agencies that we knew about. There are more.
Which 4 did you look at?
The Department of Buildings, because of Scout.
Okay.
This is where the ACP person said that they also found information. For what it's worth, you can search by someone's name. And for what it's worth, we have Supreme Court justices. You can find their home addresses that way.
Yeah.
Then it was the Office of the Chief Financial Officer because of the recording information and the integrated tax database data set, the DMV, and the Board of Elections.
How does the risk of doxing in DC compare to other jurisdictions?
Okay, I'm going to think about this risk 2 ways. 1, the probability that it would happen, like the likelihood that it would happen. And 2, this is like kind of a common way of assessing risk, right? Folks in this room, you all know this, but likelihood that it would happen and the potential like implication of it, right? So the likelihood is really high here. There are a lot of folks who are targets. It's so easy for like the Eye of Sauron, like for Elon Musk, right? To say someone's name and suddenly they're a known entity and they're getting blown up across the internet, right? All he has to do is tweet so-and-so, I don't like them because of this, or retweet something that someone else has written, Laura Loomer. And there are millions, well, in DC, there aren't that many, right? But there are thousands of people who work for the US government, tens of thousands here who are now targets or potential targets, who feel that there's a target on their back. So the likelihood is increased because we have a number of folks who are currently being targeted, and I don't think that targeting will stop or even slow down. And the message has been sent that like you can perpetrate harm against folks who live here and it won't matter, I'll pardon you. 1,500 people were pardoned in a day who attacked MPD. So the likelihood is high. The data that we have compared to other jurisdictions. So keep in mind, when we do our research, we look at tax payment portals across the country. Those are usually run by counties, sometimes cities, sometimes states, rarely states. But in Maryland, it's the state, right? So the state would hold all of the property records. They would hold all of the tax information. And of course, they hold all of the voter information. It's really difficult to get that there. It's not difficult to get that here. So I think you have to keep in mind that there are a lot of sensitive folks, and then there is a lot of data. Just for an example, so the mytax.dc.gov is the OTR's tax payment portal. When you plug an address into it to see, does this home owe any money on tax? It returns a person's name. In other counties, in other places in the country, a unique identifier like a bill number or an account number is the input, and the output is the amount of tax owed. There's no PII that actually needs to be shared this way. None. And we know that that's something that data brokers are scraping, because OCTO also provides very conveniently a list of properties, addresses, all 200, 300,000 of them in DC. All one needs to do, and we set this up. It's like, maybe you pay ChatGPT 18 bucks, 12 bucks, whatever, to tell you how to write the code in Python, then to give you step by step. I asked it like, okay, well, this is great. Thanks for this code to like scrape this, but how do I do this as a noob? And they're like, okay, step by step, you download this program, you run it on the terminal. Here's how you open the terminal. Here's how you set it up. And within a few hours, I have addresses that match names. So what the bot would do is say you have a spreadsheet, grab that address from the spreadsheet data that you downloaded from the OCTO enterprise inventory, and it would query it, and whatever comes back, it would grab it and plug it into the corresponding, like on the same row in a different column. It's just that simple. It takes no time. And our client moves her home into a trust thinking this is what she has to do, was coached by the ACP. This is what she needed to do for privacy reasons. And the way that the recorder's office records the trust is now her name as trustee. Within a week of that recordation, that's what we were seeing on data brokers.
Wait, you saw it on Data Brokers a week after she recorded the deed? How often are they turning over
I'm
that?
sure they're querying it daily. Why wouldn't they? It's money. It's so much
But
money,
don't
and it's
we
so
have
easy.
to send it then?
Do we have to send what?
Oh, I guess that's public. So they're just scraping it. Is what
They're
you're
just
saying.
scraping it. I'm sure that website was not designed to stop bots or spiders. And it isn't. It doesn't even have a CAPTCHA on it. There's no human like click this, or, that you have to like do that. Show me where all the buses are, or the cars. There's none of that on there. And it didn't return to us like, please don't scrape our site, which is a sweet thing that some websites will say, and then they let you scrape it anyway.
Okay. Thank you.
You bet.
Mr. Mulhauser. So GovQA appears to have robust reporting capabilities. Are there specific features or functionalities that could improve the system's effectiveness for public users?
GovQA is the software designed years ago by a startup precisely to be a good portal for requesters who want to send in a request for certain government records, and also to handle the internal government process of response. For a number of reasons, this is a difficult task in DC because there is no central management and every agency handles FOIA in its own way. So for example, the GovQA portal, like its predecessor FOIA Express, doesn't reach all agencies. A key fix would be for someone to require agencies to use the portal. Since you can't reach all agencies via the portal, some explanation of that problem would be useful to the newcoming unaware requester, that the Office of the Chief Financial Officer, for instance, has its own portal system. So does the Charter School Board, and so on. None of that is explained clearly on the site now, as it wasn't in the previous site. So yes, there are many ways And we have repeatedly urged them over the decade how to make these portals user-friendly. The institutional problem is that no one asks for user input. GovQA was designed by thoughtful people, so was the predecessor, I'm sure. But continual refreshment of software with user input is the state of the art, and they just don't do it.
Which agencies don't participate? Do you know off the top of your head?
There are dozens.
Dozens, okay. You mentioned the time that that OAG is spending on the public program, and can you walk us through their role?
The Office of Attorney General or the Office of Open Government?
Oh,
The difficulty that we perceive
Oops.
lies with the Office of Open Government,
sorry.
which has a limited task. You recall, it was established to enforce the Open Meetings Act primarily. And indeed, it can investigate, it can assess penalties, it can even seek injunctive relief in the courts. That's dramatic enforcement ability across all affected agencies covered by the Open Meetings Act, council and executive branch and others. There's no counterpart for the Freedom of Information Act. Its statute was written decades ago. And the work of FOIA has expanded greatly, but the management capability has not. The Office of Open Government can issue friendly advisory opinions about FOIA problems, nothing more. Appeals are decided by the mayor's office with no enforcement. So that's why we recommend that the council take a fresh look at the ability of the government to manage these areas of transparency obligations and enforce the law, which just doesn't exist now. And some of these duties are uncomfortably attached to OCTO, which is simply not an operational agency in the sense of being responsive to the public's need for functionality and the executive's need for oversight. OCTO manages the software portal, OCTO publishes the data set, and it does both in a way that aren't as good as they should be.
How do you think OCTO could improve engagement with stakeholders, especially as it related to FOIA-related systems?
It's remarkable that they held a FOIA listening session last night.
How was it?
Uneventful. They showed a video for most of the time. One person asked a question and they ended 30 minutes early. My point is not to diminish a welcome step that they took, but it's been over a decade. They don't have the staff to meet with the public, to take in or survey or to find out information about user experience. And that's simply not modern software management for user-facing systems. They know better, but they don't have the mandate and resources to manage FOIA. So they do this data effort as efficiently as they can, which means few people spend few hours on it.
What additional responsibilities or authority for the Office of Open Government would be helpful in improving the FOIA system in partnership with OCTO?
First, to manage the intake software. Second, to publish the data in a useful way. Third, to take in appeals of agency denials and decide them and publish the results promptly, which the Mayor's Office of Legal Counsel has not been able to do. You can see a pattern here. OCTO can't do its part, MOLC can't do its part, and OOG is left answering public questions about the functioning of the system. The Office of Open Government should be able to manage FOIA in a way that the statute doesn't provide now, but which the system needs as it's now grown to handling over 10,000 requests a year. OCTO built a wonderful portal for the business license part of the government, and that's important. There are 30 or 40,000 business licenses, and having your occupancy permit and your tax records and everything come together in a portal as you get your license every time, that's great. But they're not investing in this FOIA system to make data come together for good management. OOG could do that with a refreshed statutory authority.
Thank you.
Thank you.
Mr. Crane, thank you very much for testifying about your experience. Can you tell me how had the association previously tried to get the signs fixed? Do you happen to know?
It was before my time on the
Mhm.
board, but I had been solicited for information for the specific residential alley that I live in, that the association was trying to get the signs repaired. These are not street signs
Right.
in the technical sense, so it isn't a simple 311 request that can be made. It had to be made through the community engagement specialist of DDOT.
They're the little historic designation signs on on the parking signs?
The round signs that will say
Oh, those.
Foggy
Okay.
Bottom Historic
Yeah.
District.
Got it.
That were put in by the Office of Planning.
Right.
But are a DDOT asset. So in 2022, the association had worked with DDOT to identify signs that were in need of repair.
Okay. So the response that you got last month was not pertaining to your case?
No,
It was like.
it was pertaining to a workers' comp case, I believe.
Oh, okay.
I submitted it. I didn't know if I should because we're talking about data privacy, but my address is everywhere on the internet, so I just
Yeah.
submitted it. But the other claimant was through an attorney, so I submitted it with my testimony.
Got it.
And immediately I replied and said, I don't think this is my case, but
Okay.
there's no response.
Well, the agency's here today, so let's try to connect you while you're both in the building, see if we can get it
Okay.
resolved. Did you end up already repairing your car?
Yes, it was filling with water, so I had to. It was, interestingly enough, I think that one of the panelists was talking about the 311 system. ORM did cite the lack of a 311 as one of the reasons that they were leaning towards denial. We had several phone calls, but phone calls when you're trying to deal with linear facts
Yeah.
is difficult, especially when years are being misinterpreted.
Right.
I had a better time when DPW took me to administrative hearing for a trash can I did not own. There was a better understanding of fact than I've had in dealing with something that costs thousands of dollars.
Right. But you've already said here today that there isn't actually a 311 request for this type of sign.
There's no 311 request to repair a historic district sign.
Yeah.
It's not a street sign,
Right.
so
It would just be closed out if you put it in.
correct. And you work through your community engagement specialist on the ward level.
Right. Right. Do you recall the amount of the repair?
$2,700, 26 something, but just under $2,700. So it's not the biggest loss, but what was the lack of timely response?
Yeah, but I mean, that's a lot of money.
Absolutely. But I don't want to rehash the facts of what the details were. It was, we have an attorney here who deals with workers' comp, and it would just, if that sign had fallen on someone, would ORM be taking the same approach and a year later, no response?
Yeah.
And when I talk about response, I talk about written response that I can actually respond to, not a random phone call when I'm in a hearing or somewhere else.
Sure. Okay. Mr. Douglas, thanks for your continued advocacy around this issue. What type of complaints do you hear about the private sector's workers' comp program, and how are they different from ORM's program?
People get medical bills that haven't been paid. Oftentimes there's a mix-up in the office about whom to bill. And that happens in both systems, but the big difference in the private sector is we send a letter to the billing provider and copy the adjuster and defense attorney about the proper procedure. And I'm not going to pretend it's fun, it's pulling teeth, but it can be resolved, and there's not like a time frame limit, and we can take it to court if there's some serious dispute about responsibility. In the public sector system, we can do those communications, but they've got a medical provider network that restricts access. So oftentimes if they wind up at the wrong physical therapy office or whatever, it's never going to get paid. And the worker can't know that in advance. And there's a peculiar set of limiting rules about litigating these issues. So even if the bill should be paid, if it shows up late and there's no notice of determination, you can't take it to a hearing in the public sector system. That's one example. The biggest complaint, of course, is when people get cut off. And again, we litigate that in either system, but there are time windows that are narrow and sort of designed like traps in the public sector system. So if someone gets cut off and they call us 45 days later in the private sector system, we say, by all means, is your doctor supporting you? Let's work on this. Let's take it to court. Public sector system, if it's been 30 days since the notice of determination, usually that means the ship has sailed and they're SOL. Yeah,
Okay.
in both senses. So those would be two examples of the most common complaints that people have. The list could go on. There are procedures for recalculating an award that, again, are much more relaxed, much more flexible, much more oriented toward finding the facts in the private sector system, which usually aren't that complex. If we can get the right information, we can figure out how much is owed. But again, there's this time limit, which really falls hard on all public sector injured workers, but especially on those who aren't represented. And that's the majority, because they make it very hard to get counsel, create obstacles to getting counsel. There's also just disorganization. I sorry to hear you got a workers' compensation related correspondence. I had a request for audit of my client's award that I filed in December. And last week I got a notice, a response, and it was dated in December. So maybe they sent my client's document to you by accident. I didn't see it in December or in January, despite asking. So.
Okay. Thank you. You mentioned the time that OAG is spending on the public program. What's their role?
When the issue is litigated or when it's appealed, they act as counsel for the program. So at the Office of Administrative Hearings, at the Compensation Review Board, the DC Court of Appeals, or the DC Superior Court, and appeals can go multiple directions depending on the nature of the case. But OAG is responsible in all those instances.
Got it. Is that different than the private program?
Yeah, in the private program, they can retain whichever counsel, and some self-insured employers and insurance companies have in-house, some retain law firms. And I've done this for a long time. I have a real sense of when they're doing something that is helpful for their client or when they're sort of creating make work. And it's a very peculiar contradiction, because in the private sector system, a lot of times I'm dealing with firms who have a monetary incentive to create more work for themselves. And that's not to impugn everyone, but sometimes they're doing things and it's very clear that it's not going to help their client. They're running up the bill. But from a bird's eye view, OAG looks like the worst offender, even though they're not billing by the hour. The amount of work they create that's not reasonably tailored toward getting a good result is, I think, remarkable, even extraordinary. It's not good litigation practice, and I think my best hypothesis is that they're just used to the the context of a criminal court and the procedures associated with that, and they're importing those tactics without looking to the cost benefit analysis. And I also think that when ORM assesses the cost of the program, that's having this many salaried employees at their disposal to do this work, and they're very sharp attorneys. I think that artificially deflates the costs because they're not billing those, those are all salaried employees. So the litigation costs are not actually being recorded, and are difficult, I think, to calculate. I come to think of it, I don't know what records they have about the time spent on this versus the time spent on that, and I should perhaps look into it. But it's a lot of time per case, not reasonably tailored toward getting a good result. And obviously, I'm an interested party, so don't take my word for it as the final word. But I definitely stand by what I'm saying and what I'm seeing.
Commissioner Elkins and Mr. Price, thank you for your extensive look into this issue. And I'm interested to hear from Director Ross on it for sure. Have you discussed this with DDOT and ORM at all? And what have the responses been?
We included this issue in our testimony last year to the Committee on Transportation and Environment, and there was no response.
So primarily engaging through testimony, but no direct meetings or conversations?
I didn't. Chuck, how about you?
Well, I'm not sure the scope of your question, but let me just say this, that one of the issues with DDOT is that they do not collect any information themselves about the people who fall on our sidewalks. And so we suggested to them that they do they amend 311 so they could ask people who are reporting these tripping hazards to say whether anybody had been injured. They initially agreed to that, but then came back and said, no, that would be too subjective. And so they've decided not to collect any information. And the reason this is important is that they then cite the number of awards by ORM as being, well, this shows that not that many people are tripping because of problems on our sidewalks. And so they're using ORM's information to essentially drive the program. I think you're familiar with the fact that DDOT over the last couple of years has become very focused on using data to drive their priorities as opposed to how many people call them up, et cetera. I support that. I think that's a good way of running the department. But if they don't have any data, then they don't have a way of setting priorities for sidewalk repairs. And they repair potholes in 3 days, and they repair sidewalk tripping hazards officially in 270 days. So they really, this data thing is very important. And that's why Mr. Price and I are here today, is because we feel as if ORM's data are being used against the interests of public health. Not because of ORM's involvement of that, but just because I think they're being fairly strict. They're being too strict in terms of constructive knowledge, and we wanted to bring to their attention that they probably are not using all the knowledge that they should in making their determinations.
Go ahead, Mr. Price.
Also, we asked ORM if they would gather information about people who fall on sidewalks, and they also declined. That information is in our original testimony for this year to the Council Committee on Transportation, which is uploaded to your website. Thank you.
Do either of you have any estimates as to how many people you do think are falling?
Based upon our survey that we did on Capitol Hill alone, we're estimating 100 people in Capitol Hill alone. We've spoken with people who are advocates for public health safety in DC, and what we found was the Capitol experience is not unusual, that there are a lot of people who are falling. It's just, again, that the government doesn't capture the data, so we don't know. I don't know if it's in the thousands, but certainly it'd be several hundred per year. And the 100 per year are not just the people who fall. Those are the people who suffer injury that require medical care. Thank you.
Can you tell me more about your survey and how you went about it?
The survey was initiated by a a commissioner, ANC commissioner in ANC 6A, Roberta Shapiro. Is that right, Chuck?
I think so.
Okay. And she was interested in people falling. Also, at the same time, we were working with the Washington Post, and the columnist Teresa Vargas wrote an article about people who were falling on sidewalks, and that article is also referenced in our testimony from last year. Anyway, Roberta put together a survey. Then she contacted ANC 6C and ANC 6B, and they agreed to publish it on their listserv and try to get people to participate. And also Capitol Hill Village, which is an organization I work with. And also my understanding is Capitol Hill Restoration Society also participated and encouraged their members to participate in the survey. If
How many-
you need more information about the mechanics, I can only refer you to Commissioner Shapiro, and I'm sure will be glad to give you her details.
Thank you very much. Do you happen to know how many people completed the survey?
Uh, I, Chuck said it before, I think 400,
473.
Very good.
right? So out of that, we have 100 per year who were injured, requiring medical treatment.
Did any of them indicate that they had reported the falls?
There's nobody to report to. The only information that we understand that DDOT gets about people who are injured, pedestrians, is if motor vehicles involved. I think there's mandatory reporting for those kinds of injuries. Other than that, we requested last year and again this year that DC government record that information, and that's not of interest. What's interesting, though, is the Washington Area Bicyclist Association actually does try to capture information not only about bikers who are injured by cars, but also by pedestrians. And so they might have information that would be useful, but I've been unable to get that information from the organization.
Thank you very much for your testimony. Mr. Malouf, thank you for your continued advocacy about the issues at DOB. I'm planning on attending their performance oversight hearing later this month, and I'll ask ORM about your suggestions today.
Thank you.
Thank you very much. Thanks so much to this panel of public witnesses. Appreciate your testimony today. We'll now be joined by Jed Ross, the Chief Risk Officer and Director of the Office of Risk Management. Director Ross, I'm going to administer an oath to you before you begin your testimony. So when you get settled. Raise your right hand. Do you swear or affirm under penalty of perjury the testimony you're about to give to the Committee on Public Works and Operations is the truth, the whole truth, and nothing but the truth? You may begin your testimony.
Good morning, Chairperson Nadeau, members of the Committee on Public Works and Operations, and staff. I'm Jed Ross, Chief Risk Officer and Director of the Office of Risk Management, ORM. I would like to start by thanking you for your time and service to the district residents. It is always an honor to be able to testify before the committee, not only on behalf of Mayor Bowser and her administration, or myself as the Director of ORM and a district resident, but also on behalf of our dedicated team at ORM and valued constituents. During my tenure with district government, I have served in various capacities, and I've found my time at the Office of Risk Management to be both worthwhile and extremely gratifying. Being able to witness firsthand the growth and improvement of the agency's operations and contribution to fostering a more risk-aware government has been a highlight in my time here. And I look forward to continuing this momentum with your support. ORM continues to reduce the probability, occurrence, and cost of risks for the district government. In alignment with the Mayor's DC Comeback Report, we strive to contribute to the district's successes by focusing on initiatives such as public safety, health, education, and our growing workforce. To achieve success in these areas, we provide risk management leadership, guidance, and support to district agencies through ORM's 4 main divisions: the Public Sector Workers' Compensation Program, PSWCP, the Risk Prevention and Safety Division, RPS, the Tort Division, and the Captive Insurance Agency. As I present you with ORM's performance achievements in fiscal year 2024 and 2025, I hope you will recognize the key theme of partnership and collaboration. ORM has been working in close partnership with district agencies to commit to and establish best practices in risk management that reduce the likelihood and severity of potential losses, promote safety, and provide exceptional constituent services to district taxpayers and employees. Let's start with the PSWCP. Over the past year, the PSWCP team has successfully conducted several trainings for agency managers on workers' compensation to help strengthen the process around incident reporting and supporting return to work efforts. Some of these agencies include, but are not limited to, DC Child and Family Services Agency, the Department of Disability Services, and the Department of Public Works. In moving on to RPS, in FY24, RPS worked with District of Columbia Public Schools to increase the number of school inspections, identifying improvements needed to provide a safer environment for our teachers and students. In coordination with the Department of Human Resources, RPS also led several new employee orientation briefings with key information on incident reporting and how to stay safe in the workplace. The Tort Division, which investigates and resolves tort liability claims filed against the district and collects revenue and distributes payments related to subrogation activity, has worked with the Office of the Chief Financial Officer to improve the process around timely management of settlement and judgment payments. This collaboration comes at a vital time, given an increase in claims over the past year. Last, but certainly not least, the Captive Insurance Agency has had a productive year making strides in several initiatives. The Captive has worked with the Metropolitan Police Department and Fire and EMS, the DC Department of Transportation, and DPW to support the district's new drone program with risk management and insurance guidance. Also, in cooperation with the Office of Contracting and Procurement, the Captive formalized insurance standards for district contracts to provide additional transparency about consistent application of insurance requirements across the district. In addition to training contracting staff on these insurance standards, the Captive also convened an interagency working group to address the related yet outstanding insurance needs of the district's contracting community, specifically the CBE Certified Business Enterprise community. The working group consists of agency partners from the Department of Insurance Securities and Banking, the Department of Small Local Business Development, and the Department of Licensing and Consumer Protection, NOCP. Through these and many more collaborative efforts and partnerships, ORM strives for continuous improvements in providing top-tier service to our customers and constituents. ORM remains committed to providing support and risk counsel through education, compliance, and partnerships, including this committee. Before I conclude, I very much want to acknowledge the amazing team at ORM who work every day to support district government employees, the administration, and our residents. I think it's, it should be noted our wonderful civil servants at ORM, they don't have a very easy job, and I'm very thankful to call them all my colleagues. And again, thank you, Chairperson Nadeau and members of the committee for the opportunity to testify before you today. I believe our performance reflects Mayor Bowser's ongoing commitment to our shared DC values. ORM looks forward to your continued support and open communication, and I'm available to answer any questions you may have at this time.
Thank you very much for your testimony. What do you see as your role as the head of Office of Risk Management?
I'm definitely no Shakespearean scholar or poet, but in my role, I believe I'm a civil servant, dedicated to partnering, educating, and supporting the administration, our employees, and our residents, figuring out ways where we can proactively reduce risk. And then when risks come about, figuring out ways to proactively address them. We don't want to be simply reactive. Oftentimes, a lot of our work is in that we have to respond when issues come up and figure out the best way to manage and mitigate those issues as they arise.
Thank you. Last year, we discussed compliance issues with emergency response plans, which ensure that district agencies create documented procedures for responding to emergency events. Compliance is up to 85% compared to last year's 55%. What contributed to this increase?
I'm again, thankful to my risk prevention and safety team, to Pat Healy, Angela Mandel, and all the team members who worked diligently with all the agencies to ensure that they were appropriately submitting their emergency response plans and getting them approved through FEMS appropriately. So the team worked really hard to make sure that we were bringing up in all of our meetings and coordination with all of the agency risk management representatives, and pushing hard. In addition to that, outreach to directors to make sure that they were working to be in more compliance with the needs.
Your agency, all of the staff you mentioned, I'm sure work hard every year. So what made the difference? Is it, the agencies have fewer, are there more confirmed agency heads now that have authority? Were there staff gaps in the different agencies?
So simply, most agencies are doing their best. They're always working to get the information to us, and we just made an extra concerted effort from the division, from myself, my fantastic deputy. Everyone was working to reach out to agencies and make sure that they were getting the data in. We were following up on it as a regular trigger after the committee had raised it as an issue, making sure that it was happening. So we all together collaborated all across government to make sure we got and met our performance metrics.
I want to talk about the How Am I Driving program. We've been discussing this program since last year, and I'm encouraged by the positive updates, including that ORM is in the process of creating an automated feed for tickets. However, in data that you all sent over as part of your pre-hearing responses, you still have quite a few open cases. In these cases, ORM is sending the complaint to the agency who doesn't respond, and then the case submitter never receives a response. How do we get this resolved? Do you need greater authority with the agencies? Do we need to publicly shame the bad actors? What's the best approach here?
So as we discussed, we are working on an automated feed. We also are highlighting it directly to the directors, ensuring that they are going to be addressing it. So I think we're in a pretty good position. I think that the agencies, everyone wants to do the right thing. I will also say that there are just in general, it is a getting and receiving the ticket information and getting it timely and then getting it to the right people and being able to track the right employees. It becomes a bit of a burden and a challenge in order to properly do that work. But it's something that we're committed to, and I think agency directors are committed to it as well. We've been working hard to have processes, as I said, in my responses, we are working on that automated feed. And the goal for that is that people will get information faster and can respond more effectively.
When do you think that'll be ready?
I think it hopefully should be ready in the next couple of months.
You let us know when it's ready.
Happy to do so.
Okay. So MPD and DPW were some of the worst offenders for not responding to ORM, and I'm planning to ask DPW about this at their hearing. Have you discussed it with the agencies?
We've talked with them and they've been making concerted efforts to improve in their responses. So we've had high level conversations, emails, coordination in order to make sure that they're addressing it more robustly.
And who at the agencies are receiving the complaints?
So we're working with the agency risk management representatives. And then when we aren't getting responses and details, we'll then work with agency leadership. I will say, I know that when we reach out to the agencies, often they are reaching out to their staff. And it's just a matter of, big, really important agencies doing really significant work. Sometimes it's hard for them to get the responses. So I don't think that it's necessarily a lack of willingness or desire. It's more a matter of being able to get to the granular level at the employees and their driving practices and what happened 3 months ago on this date and this time. And it gets to be a challenge to ascertain those specifics, but everyone wants to do the right thing. And we're trying to build a culture of safer driving practices. We're working with the agencies around that. We've been working with about more training for it. And of course, as you know, we regulate authorizations for drivers. So there's a lot that we're trying to do to improve on the process related to it.
Great. Turning to some of the testimony we heard today about ORM's role in addressing pedestrian safety issues and other infrastructure in the district, I'm particularly concerned that there may be hundreds of residents being injured on DC sidewalks.
Chair, I can speak a little bit to that.
I have questions, but if you want to react, that's great.
To my knowledge, we typically get about 70 to 90 claims a year.
Okay.
So the numbers don't necessarily equate to what our data is.
Yeah.
I'll say our data is we receive a claim and that's how we know about it.
Yeah.
We always, for every claim, every notification that we receive, we look to the agencies as the experts. We reach out to the agency on each and every one of those claims. So we follow up with each and every one of them, and then we continue to follow up with the agencies until we have an adequate answer in order to accept or deny liability. We also, when we become aware of a hazardous condition, we work to notify the agency in order to correct it. We have very good partnerships, and we speak about these things regularly, including in our risk prevention and safety team, reaching out to the agency risk managers, my deputy, myself, my leadership team, my tort manager, all of our partners. We reach out to the agency to notify them whenever we become aware of an issue. If it involves an injury, we address it definitively. If we identify a risk, we notify them and ask them to correct it.
Of the 70 to 90 or so, how many get paid out?
It depends on the facts. Each and every case is fact specific. So I don't necessarily have the specific of how many. What I will say is if the District of Columbia has constructive notice or actual notice of a defect that has caused damage to property or an injury to a person, we work to pay out that claim. We accept the liability and we're willing to pay it. There are times when individuals will not want to, be paid by our tort team, and they file lawsuits, and then it becomes an attorney general defense matter. We don't have the ability to do discovery or to get all of the medical records if we need to pay somebody. And if they don't want to provide that to us, we're not going to pay a $5 million, claim on a knee injury. Then it has to go to, the courts.
So the way it works is someone files a claim, they submit like the medical documentation, and then you investigate whether you think the district is at fault. And if so, then you would pay out the claim that they present on its face.
We work with them to negotiate on the settlement amount
Yeah.
based on all the factors as if we were in a court proceeding,
Okay,
pre-litigation.
got it. And then if they're not satisfied, they take it to court.
They cannot accept our
Got it.
offer, and any one of our claims can be, there's a 6-month statute. It's the 12309 statute, which requires they provide us notice of the loss within 6 months of the date of injury. And then from that point, we work to negotiate and settle out that claim as best as we can. There are many times when we are not responsible or we had no notice. And as a result, the taxpayer shouldn't pay for that. And that's why they have their private insurance for whatever their particular circumstances are. But if the taxpayers and the district is not liable, we obviously don't accept the claim.
So the notice would be a 311 request for a sidewalk repair.
That can be one. There's other constructive notice elements. It can be that an employee, say a DDOT employee, is canvassing an area and puts in a service request saying, we need to fix this particular thing. It could be an email from an employee or a district resident. It doesn't necessarily have to be 311.
Got it.
But we do have to be notified. DDOT has to be aware of a particular issue in order to correct it. If they aren't aware of it, then we're not necessarily responsible or liable.
Does ORM ever take into account sort of like age of infrastructure and best practice for replacement?
100%.
Okay.
We'll go to Google and look at the old pictures
Yeah.
to see what it looked like in 2017.
Yeah.
Should we have noticed as constructively, should we have notice of this?
Yeah.
If somebody had driven by 30 times in front of Pennsylvania Avenue, in front of the Wilson Building, and they saw a pothole issue over and over and over, we're going to say we have constructive notice, and we accept claims like that.
Okay.
So it is not, there is not a singular time where we're just denying claims because of data. We have to look at every specific fact. I would like to speak briefly to the comments from the association on Capitol Hill. We'll take every and all factors, but a report on whether a road is fair or not, or good or poor, it doesn't necessitate a decision point. The decision point is, was there an actual defect in that particular place that we had notice of that caused a particular harm? And so we look at the specific facts, and if that is the case, then we will accept it. But we're not doing that in a vacuum. We are reaching out to DDOT or DGS or DPW or any of the agencies who may have been a factor in that particular claim or responsible agency. And we are following up to make sure that we're getting the agency's input before we accept or deny a claim.
Do you think people typically know they have the option to file a claim?
We got 1,784 claims in 2024. So I think that there are, residents are aware. I don't necessarily know that everyone is aware in all ways, but we get claims from visitors, we get claims from residents, we get claims from constituents. Whenever the district is potentially liable for something, people know you can sue or pursue an administrative process to have a wrong righted, at least from a financial perspective.
Do you think that the audit that Capitol Hill did would be useful to ORM?
I think anything that we can learn about potential risks impacting the district is a great thing. Any way we can do that. I will say I have spoken with the director at DDOT.
Yeah.
I know that the director is having and has had many meetings about sidewalks with many constituencies, including that constituency base, and is working to make sure that we have good solutions. I think that one of the conversations was the potential openness to switch to concrete. But again, it's a historic district, it would require legislative changes, and then that
Oh, 'cause
changes.
there's a lot of brick in Capitol Hill. Bricks come up. Got
I
it.
mean, it's just an inherent part of the process for a
I do
historic
not want to
district.
wander into the
And
great
so
brick
there are
v. concrete
there are
debate.
all sorts of factors that play into this. I will say that, my belief is that the District of Columbia has much better sidewalks than many other places.
Sure.
That doesn't mean that there's not always work to be done.
Fair enough.
And DDOT works very hard at it.
Yeah. I will note that when I was in ANC, that brick sidewalks were the bane of my existence, and I always advocated against them, but
Only
Wasn't
so
it?
much we can do, Chair.
yes, exactly. Okay. Let's see. ORM has projected that recent weather events have negatively affected sidewalks. How is our government thinking about that and preventing injuries?
Thanks for the question. I recently was speaking with one of my friends who was coming into work the other day, and he was so surprised at how great DDOT, DPW, DGS, all of our roads had been cleared. So I want to just acknowledge how fantastic the administration has done. The mayor, prioritizing it. We've been able to really function on all our main roadways. I will say that we've been fortunate in years past with milder weather, and the snow and the inclement weather does play an impact on
on potholes in the district. I know DDOT is thinking very strategically about it. I did talk with the director about this specifically. They have their programs and processes. They have major efforts in April that they're going to take once the roadways can handle it. Oftentimes, potholes are caused a lot by our utility partners who are going in and kind of making minor changes or fixing things. And then those small little impacts to our roadways kind of can get bigger and bigger over time with the weather. So they are going to be working with them to remind them and the repairs, and then of course just do the consistent hardcore efforts that we do every year to fix and update all of our roadways as best as possible. I think overall DDOT's been doing an excellent job in terms of fixing the roads, and then of course DPW did an amazing job on snow.
So, you know, we have this law that you have a certain amount of time to clear your sidewalk after snowfall.
I'm generally familiar, yes.
It's like 8 hours after the snow stops, and then we can ticket you. This is presumably for private parties, but where do you consider the liability? Two categories. One, sidewalks not cleared by us around our properties, and sidewalks not cleared by other government entities like NPS.
I thank you for raising that. We do always, to add to my prior comments, we also look at, from a liability perspective, whether or not it's federal land or third party owned land, and we'll deny those claims and then send parties to those third parties. If we failed to maintain something that was under our purview and responsibility and it caused a harm, we would work to accept liability and settle the claim. So if it's a sidewalk that's our full responsibility, of course, we're tasked to meet the same obligations as residents. There have been conversations internally at the Office of Risk Management, and I think just in general, even with the Attorney General, about shifting some liability theoretically on the commercial side of it. If you have a business and you're not maintaining your sidewalks, that could be your responsibility. But we haven't really pushed forward on any
Well,
legislative.
it is legally their responsibility right now because we can ticket them if they don't do it. But my follow-up question is, we have the ability to ticket. We're not really doing it because there's nobody to do it. DPW is all hands on deck every storm event. They don't have time to send people out to ticket, which is an uncomfortable truth. We're going to figure it out. But is that additional liability if we're not actually ticketing those?
I don't believe that there's additional liability.
Okay.
It's the responsible party is the responsible party, whether
Okay.
they are fined or not. But ultimately, we look at each and every fact, and it's very fact specific. So
Okay.
oftentimes people will ask us, what can we expect from a financial perspective, or what can we expect from this? Each and every year, there's different claims, different issues, different incidents that occur. But in that particular instance, you definitely have it, Chair.
I want to ask about Mr. Crane's case that we heard about earlier, the historic sign that fell in his car. It sounds like, is that a typical response time for that type of claim? Still waiting a year later?
So generally, no, we don't take a year to respond to claims. As I said, we reach out to agencies the day after at most to follow up with any claim that we receive in order to get information. Specifically on that case, but there's not necessarily PII data around it. So I'm always very sensitive on the workers' compensation front. But we received the claim 4 months after the sign fell.
Okay.
From the date of loss that was reported to us.
Okay.
It took 4 months to find out about it. And we didn't necessarily have any evidence to prove that it was how, when, where, why any of that happened. We received a photo that showed the sign next to a pole. And then a month later, we got information from DDOT that a month after the sign allegedly fell, there were requests from that community requesting a sign to be put back up. A month later.
Got it.
We still didn't receive any claim until I believe it was March. So 2 months after that. So sign fell, allegedly the sign fell, allegedly the sign hit the car. A month later, a request was made to get new signs put up, which can be done through 311 to be 100% clear. If there's a record of it,
Yeah.
that a request was made in 311, whether it'll go to DDOT, and DDOT needs to route it to the appropriate parties. And I believe that they will do so. So it's not as though 311 will take a call for any particular resident issue, whatever it is, and there will be a record of that. And so sign was requested, and then 2 months later, 3 months later, 2 months later, in March, we then received a notice of a claim. And at that point, then we started our process to reach out to DDOT to try and ascertain facts. DDOT went to go look through the records, multiple follow-ups, in order to get to the information that we had to get to. And at that point, we had no evidence to show that that was definitively the way that the damage would happen to the car. There was no other data points that were provided to us. It was the photos. If there is, and we'll welcome reopening any claim if we can get more information about prior
It's
notice.
unclear if it's even closed at this point because it sounds like the response was not.
So in January this year,
Yeah.
a notice was sent. And
Yeah.
it was sent to the email address and it was mailed out. So I
Okay.
think
But
that
it-
it was, and there were phone calls that were had between the claimant and our adjuster, but no other written, we don't generally write to people in the middle of trying to ascertain liability to say, we're still working on your claim. We'll have a phone call and we'll talk about it and say, do you have
Oh,
other
yeah, but
facts?"
he was just saying he got a response that seemed to be related to something else.
I welcome looking into
Yeah,
that
will you?
information. I have not seen it, but he said he provided it.
Oh, yeah, we can send the testimony.
I definitely am happy to look into that. That's something that I am unaware of, and nothing that I was able to readily find when I heard about it first thing, this morning.
Did you hear the testimony about the Department of Buildings and a potential role for ORM reducing risk for construction liability against the district?
I did, and Mr. Maloff's been great in sending us information and about his requests, and he's reached out on prior occasions, and I've been good about responding to him. There's only so much that I can necessarily do or will do in that particular instance. I definitively will defer to the deputy mayor and to the city administrator for their regular oversight to make sure agencies are performing their tasks. Obviously, the council and the committee in terms of their oversight functions, it's not generally something that we just go and randomly pursue an investigation or dedicate team members based on a resident request.
Right.
I think it's something that should come from the administration as a decision to say that there's a problem. And I'll say ultimately, I believe, the leadership is working very hard there. I think they are capable. I think they are working every day to be as great as they can possibly be. And so doesn't mean that we don't all in government always need to have improvements. So I think that's an inherent fact of how we can always be doing better to serve our district residents daily.
Okay, moving to the public sector workers' compensation program. As I mentioned earlier, I've consistently heard criticism of the program since taking over as chair of the committee. Specifically, we've heard that ORM is not the correct place for the program. You said earlier today, you see your role as director as reducing risk for the district, but that's not what a workers' compensation program is about. And that's the main criticism that we continue to hear, that ORM is running the program in a way to reduce risk for the district instead of taking care of our employees. I know that you have drastically reduced the number of open claims from 1,823 in the year 2018 to less than 700 in 2024. Do you know how many of these claims closed because they reached the 500-week limit?
Offhand, I do not know that. That is something that I can look into. I will say that without a doubt, we have a large, compassionate, dedicated public sector workers' compensation staff who every day are taking phone calls, working on people's medical care, ensuring people are getting paid timely, for their lost indemnity payments, their lost wages. And we do and bring compassion every day in what we do to take care of our injured workers. I myself, if I got injured, we'd be a participant in the program. This committee, any staff on this committee, you as chair, we would take care of each and every person with compassion and try to make sure that we're effectively and appropriately taking care of people. Our program is built to return people back to work. It is not built to simply be an insurance payer. It is not the private sector where we are transactional from a financial perspective and don't care about the life impacts when our employees are hurt on the job. So it's a consistent mischaracterization that seems to keep happening. And the approach that we take is about returning people to work, saving their jobs, ensuring that they can have income while they are recovering, and return back to their job where they can continue to pay into and participate in retirement and social security programs that are not necessarily the focus of the private sector. And so obviously there are certain advocacy groups that want to express a narrative that is simply untrue. We received last year 784 claims of employees getting hurt, 784 people. And so I don't see 600 people here testifying about our poor service or our lack of compassion or us not following up to make sure that we're appropriately providing care, prescriptions, or any of the things that we do every single day. We processed over 3,000 medical bills last year, right? So that's 3,000 individual visits that we're taking care of people all day, every day, in a very difficult environment where people are hurt and on the phone, upset, looking for our support and care, and we're doing that. Are there times when we have disagreements? Are there times when we're following the laws or the rules or enacting obligations? Yes. And we have, it is an insurance program. Workers' compensation is insurance. There are private products that you can buy for it. We don't argue about whether or not the employee contributed to the injury. Did they somehow cause it? It's simply the relationship and the deal that we enter into is that if you're hurt on the job, we're going to pay for it and we're going to work to support you. And that is something that we take very seriously and something that we do every day. And so I believe firmly that our program is doing a great job. I think that we are responding to people. Are we perfect? No. But I will say, compared to where we were when this administration took over, 1,800 down to 600, 700, we are responding to people. We have due process. We have processes. They can appeal any matter where we determine that we believe somebody can return to work. They have the ability to appeal that. And the Office of Administrative Hearings, I heard earlier that there's 30-day timelines, which is statutory. Just to be clear, it's not a regulation, statutory obligation. But OAH regularly, for good cause, will extend and allow for those cases to continue. I think it's one instance where a judge doesn't do that, an ALJ. Okay, that might be the experience that we might hear about. But if we're talking about 60 cases that are being litigated and there's one or two where there's a problem, overall, out of the large numbers of cases, 784 in a year, I think our track record is very clear. I think we're doing an excellent job. And my team, I'm forever thankful to them every day taking care of people. So I know that was a long response, Chair. I apologize for it, but I will just say, the narrative that our program is bad or that we shouldn't allow people, we have 313 different offices for medical care. And the injured, our DC government employees who get injured can go to anyone. They get the option, right? It's not as though we're singularly saying you can only go this place because we know they're going to do a good thing for us. That's not the case whatsoever. We want great care for each and every injured worker. And we want them to be able to go to somebody who's going to provide great care for them. So that's kind of our that's how we address this. We approach it every day.
Thank you. In testimony today, I heard concerns about delays in responses from ORM despite the decrease in caseload. Are you aware of delays?
I generally am not aware of any delays. I will say if there are times when if we get the wrong email address, I think there was one circumstance where we didn't have a right email address and the email was going to one place but not to another, involving an attorney. But generally, I think we're meeting our goals. We're responding to people. We're not perfect. There are times when things could get lost in the mail or there can be issues, but I will say overall, we're providing support on every case, on every claim, and trying to do our best. And if there are ever issues that need to be raised, Jennifer Arnick, Merle Gaither Morgan, like our team is very responsive.
What are the goals that you set that you're saying you're meeting?
I mean, in general, our goals are to be responsive within a reasonable period of time. I mean, if it's a phone call, right, we follow the mayoral process. We try to get back to people within 24 hours. If we get an email, we try to get back in 48. Depends on what's, the factors are. Oftentimes
Gotcha.
we're waiting on data from medical providers. So we can't always, get a response. We're working to schedule appointments for people or follow up with things. And so those things kind of, those can create delays. That creates lengthy processes for certain things, but those are when they're outside of our control, compared to the things that are within our control.
Does ORM track litigation performance related to the public sector workers' compensation program?
We do. We do track it. We work to, we track the decisions that are issued by the administrative tribunals. The Compensation Review Board reviews decisions from the Office of Administrative Hearings. And then, we work to get those decisions and make sure we're following up to adhere to them. I did note in some testimony, it stated that we don't adhere or that we believe we don't have to adhere to orders. I mean, it just factually incorrect. I'm a lawyer. I have an ethical obligation. My entire office, we have an ethical obligation. We respond to court orders. It is our obligation to do so. We would never purposely ignore them. We may want to appeal them. We may request a stay and say we think that the ALJ made a big mistake or that they didn't do something properly, and we'll, within all of our legal rights, follow to protect the district's position. But we follow court orders, and we know that is an absolute. There's no questions around that. So, yes, we track our litigation. We get all of our decisions. We've worked with the Office of Administrative Hearings and requesting to try and make sure that we get those decisions in a most effective way. There are times when they're mailed or they might go to the wrong place. So conversations have been had to make sure they're being emailed out, and their communication's effective. Things do go to the Office of Attorney General that don't always come to the agency, or it might come to the agency and not go to the Attorney General. I sit on the Office of Administrative Hearings Advisory Committee, and then I work to, request to make sure that they improve their processes so we can also always be responsive.
What is the current overturn rate for cases litigated by the Contract Review Board?
So in terms of an overturn rate, so first cases are heard by the Office of Administrative Hearings.
Yeah.
So it's those judges. So the ALJs at OAH are making the initial determination.
Okay.
And then it's the Compensation Review Board at DOES, and then it's the Court of Appeals. So there can be multiple overturnings that happen, and it really depends on which judges and which particular views. Obviously, we work to appeal when we think we're within our rights, and we do that through the Office of Attorney General. And so we'll go at different levels, and then the Solicitor General at the Office of Attorney General will appeal to the Court of Appeals. Sometimes those are overturned. So it's a very there are many different levels to when it can be overturned or when our decisions are overturned. I have previously testified, and I will say, if a decision comes back to me, there are times when I will also overrule the program. So, we look at every factor, we look at every case. There's no one particular trend that I can clearly identify for you, or no factor where I can say we're being overturned all the time or that we're winning all the time. I think each and every case has its very unique facts. But I will say, given our numbers, given our reduction in claims, we are working in resolving workers' compensation injuries. And I think we've actually really come to a very good, stable place where I don't see us having a significant, massive reduction in claim counts. I think we're really kind of at our steady state where a new claim will come in and we'll be resolving an old claim, which is kind of industry standard about how you should be working on claims in general.
Mhm.
That you should never be growing your claims if unless something happens and there's a mass issue for lots of people. Otherwise, you're resolving them and getting rid of them. When I say get rid of them, we're solving them, lowering our case numbers in order to make sure that people are back in the office.
Mhm.
We've had hundreds of people returning to work, which is a success. It's showing that we are giving people care, we're providing them with the support they need, and then they're getting back to work.
Okay. But it is my understanding that the Compensation Review Board continues to overturn ORM decisions pretty often, and that the claim decision that they're pretty high, that's pretty high.
If that's happening, then they're overturning other administrative law judges' decisions. So if OAH is making a decision one way and the Compensation Review Board is saying OAH is not doing it right, it gets remanded back to Office of Administrative Hearings,
Mhm.
and then they get to review and make adjustments to whatever their decisions were. So I mean, that would be a judge saying another judge didn't rule effectively.
But on your case,
Sure. So, I mean, if
on a
the
claim.
Compensation Review Board might overturn a decision that was counter to what we have done. So we might appeal and they might overturn that. Or we might have made a decision and done formal filings, enabled people to file an appeal at Office of Administrative Hearings. That ALJ would have potentially agreed. There are times when they don't agree. I would say a good number of times when they don't agree with our decisions, or they're looking for ways in order to extend benefits to individuals when we don't believe they're entitled to them.
Mhm.
And every scenario kind of plays out. I'm happy to do a little bit more analysis and speak with the committee about it.
Okay.
But
Let's do that.
yeah, happy to do so.
Yeah, because if you're saying the number that we're looking at is a combined number of, in your favor and against you, then that's helpful, but I'd still like to get that data and understand it a little better. Okay.
Happy to look into it, Chair.
Okay, I want to talk a bit about ORM's rulemaking over the past decade. First, the 2017 regulations appealed much of the 2012 rulemaking that were developed to, and this is a quote from the rulemaking, protect the due process rights of employees and enhance the transparency of PSWCP policies. In 2017, ORM made the decision to repeal these sections, including language designed to give claimants notice of their rights. ORM cited there was no legal requirement to do this, and then it created an administrative burden. Can you share more about the administrative burden and the rationale for removing this rulemaking?
I can speak in general.
Yeah.
That in 2017, we were getting rid of our third-party administrator.
Right.
And we took over the program in 2018, which required us to implement a process by which we effectively manage workers' compensation claims.
Mm-hmm.
I will tell you, when this administration came in, when I came into the Office of Risk Management, we had numerous cases where we were not being responsive to court orders.
Mm-hmm.
And there were numerous times when people could not file appeals. And so what we did was, and I believe they got finalized in 2019, 2018, 2017 we have not had any other regulation changes since 2019. So going on 5 years, over 5 years, but we put in that on every one of our forms, we establish our appeal rights. So every time we make a decision, the appeal rights are very clear at the bottom of the documents, allowing people and educating them about how they appeal, where they appeal, the forms that they need to get to appeal. And in no instance have I ever heard where we have refused or prevented or purposely attempted to prevent people from getting to appeal a decision that we've made. The office is dedicated to due process and transparency, which is what we spoke about. We were getting rid of confusing, difficult regulations that weren't effectively managing workers' compensation cases. That was a quagmire for lawyers, for injured workers to figure out how they would navigate through a process. So we made it more simplistic. We created 11 forms for appeals to happen that didn't exist before. We created actual forms for particular issues. We cite to those on our notices to ensure that people know what to appeal. So, we have this, the significant reduction in claims is a direct correlation to appropriately giving due process and enabling people to know what to do and how to do it, which is what we have been doing since 2018, nothing new. So, and that is why administrative law judges can actually rule. I think historically they were always ruling against the agency because the agency wasn't following good practices, didn't have good regulations. So I think that's kind of the high level of what we did back in 2017, 2018, and 2019. Our regulations have created due process, created a process by which people can appeal, created transparency for people to understand what is going on and ask the questions and have somebody to respond to it in order for us to be an effective program. Before that, it was not as effective as it should have been. And I think a lot of cases, a lot of claims, and a lot of injured people languished. And so that is why these claims have been reduced, because we have a process that actually works, that's effective. People don't always like it. They want it to be different, or they want it to be more favorable, or they want it to be in a better way in what they think. But ultimately, the vast majority of our processes are working and working effectively.
You've also said that ORM is working to publish a manual, a PSWC manual as another avenue to give claimants notice of their rights. Has this been developed? And if so, where is it available?
We've developed three sections, and that is available, I believe, on our website. But we are continuing to put out more. And we are working this fiscal year and next to have it, each section, each chapter that will get done, we will publish. And so the goal is to have all of them up and available so people can have more transparency. I will just say, any question that's ever asked, we're responsive, and all of our forms, all of our letters of decisions establish the due process for people to follow.
How many sections do you anticipate?
I think it will probably be around 9.
And are the ones that are posted now translated?
I will have to double check on if they are. Of course, obviously we want to be in compliance with.
Are they in plain text or PDF?
I believe they are in PDF at this point, but
Okay.
there's PDF that probably that's easily transferable to plain text, but
Okay.
I'll follow up on that.
Thank you. Let's discuss the 2016 regulations that eliminated the permanent total disability benefits, which you said was in response to a 2015 council amendment that intended that change. In November 2023, the DC Compensation Review Board had this to say about the regulations. Such a draconian outcome is entirely in opposite with the humanitarian purpose of the statute. The argument is burdened with strained reasoning and functionally blames the council for not foreseeing ORM's unusual interpretation of the statute. Nowhere does it suggest or even imply that permanent total disability was repealed or otherwise eliminated by the council. End quote. I think that opinions like this are why people say that ORM is not listening to legal opinions. I want to get your take on that.
Happy to speak on it, Chair. So after that decision, we've been working to update regulations in order to affect the implementation of that. I will say, I submitted, I believe, with Chair Silverman back when she was chair overseeing this agency, a permanent disability piece of legislation to clarify and ensure that there was accuracy
Mm-hmm.
on that particular issue. We felt and we believe that the way that the law was changed, it didn't give what it should have given to injured workers. And so we're not, it's not falling on deaf ears. It's not something that we haven't done. We actually proposed legislation to properly put this into place. And so it didn't get put forward, and it didn't become enacted as legislation, which is fine. So ultimately, when the court ruled, we're going to work on regulations in order to interpret the murky language that we believe didn't really give those benefits in a way that can effectuate what we believe is right, which is giving permanent total disability. So we are in favor of it. We have been in favor of it. We propose legislation in order to put that in place. So I will just say I would take any advocacy groups or any third parties that say that we are it's falling on deaf ears or that we don't care. I don't find that to be accurate if we were proposing legislation in order to try and address it.
Okay.
But we are working on rectifying it, and we will do that hopefully through a regulatory change so we can make sure that it gets effective and that people can be entitled to their benefits.
Great. The 2017 National Academy Report also found that the temporary total disability weekly maximum in the PSWCP is more than 20% lower than the weekly maximum in the district's private sector. Is that something that you've looked into?
Sorry, Chair, can you repeat that one more time?
Yes. The 2017 National Academy Report also found that the temporary total disability weekly maximum in the PSWCP is more than 20% lower than the weekly maximum in the district's private sector.
So we pay 66 2/3 of what people receive with a cap up to a 12-step 10. It's a very complicated process, but people are entitled to receiving around $3,000, give or take, right? It's up to $3,000 every 2 weeks, depending on where they are on their pay scale for the district. In addition to that, unlike the private sector, the District of Columbia continues to give pay increases. So whenever a District of Columbia government pay increase is given for non-union employees just across the board, the same percentage increase is given to injured workers. And so, so say somebody who was injured 40 years ago and was entitled to $375 every 2 weeks, that individual has been receiving pay increases with cost of living or other pay increases that are across the board. The private sector does not allow that.
Mm-hmm.
We are paying, I would say, much more than any other jurisdiction in the country. There are no other jurisdictions. From an insurance benefit, if you think which workers' compensation is, you get, you get an insurance policy and you get paid the same amount for the life of the policy. That policy ends, say it ends in 30 years, say it ends in 10 years, whatever that period of time, or when the limit has been exhausted, that's the end of it. So I think $3,000, I think that, council's the one who enacted the law about what the maximum amount is in the Merit Personnel Act. Around $3,000 per pay period is what the cap is. It was $2,800. But it's been increasing over and over and over. So I don't know. All I can say is each time there's an increase, our injured workers are getting increases, which is not happening in any other jurisdiction in the entire country, which is better than the private sector in the district and better than everywhere else in the entire United States.
Thank you. One last thing, we're going to follow up on this, but we had asked to see all customer survey data through 2025. We only received it through 2020, probably just an error. So if we could get that, it would be Great.
Happy to provide that data to you for sure.
Thank you. That's all the questions that I have for today. I appreciate your testimony. This concludes today's public oversight hearing. If you plan on submitting written testimony for the record, please do so by going to the council hearing management system at lims.dccouncil.gov/hearings. The record will close on Tuesday, February 27th at 5:30 p.m. I'd like to take a moment to remind everyone the Committee on Public Works and Operations will be holding several more performance oversight hearings over the next month. Please visit the Council Hearing Management System for the committee's performance oversight schedule. To testify to any of these hearings, sign up at lims.dccouncil.gov/hearings.